All right, good afternoon, everyone, and welcomes to today's second Wednesday session where we are chatting with Courtney Agrusa, one of our attorneys here at Foster Swift, on a incredibly timely matter. And this was an executive order that just came out, less than a month ago, regarding the possible rescheduling of marijuana and kind of the implications of that in the employment context, right? And we can all agree, if marijuana is in fact rescheduled, there are a plethora of implications, right? You have implications dealing with, how we're, the FDA approval requirements, taxing of, something that was previously an illegal, Schedule 4, I think it is, drug. All the safety regulations, all the business regulations, all those sorts of things. But today we'd like to kind of focus on the employment side of it. So, Courtney, thank you very much for taking time with us today to talk about this topic.
Thanks, Rob. I'm happy to be here.
Yeah, perfect. So, why don't we just kind of dive right in? So, Courtney, can you kind of give us a general overview of what's happened with this executive order and kind of why we're talking today?
Okay, so the executive order that we're talking about, like you mentioned, was signed by President Trump on December 18th of 2025. So it's really new. We're less than a month, right?
Hmm.
And what's really interesting about this particular executive order is it talks about marijuana. Specifically, this executive order is directing the Attorney General to reschedule marijuana from a Schedule 1 drug to a Schedule 3 drug under the Controlled Substance Act, which is a big deal, right? A lot
Right.
of people are talking about it.
Yeah, I think I may have said Schedule 4 beforehand. I always revert
Nobody's
to that. I
judging.
apologize. Not my area of law. I'm a corporate attorney, not a medical attorney.
We'll all keep our judgments to ourselves. It's
I
okay.
appreciate it. Thank you. Thank you. So,
So, oh, go ahead.
yeah. So, in the context of that, I know that you're going to talk about a lot of different areas, but fundamentally, the movement from a Schedule 1 drug to a Schedule 3 drug is like a reduction, correct?
Yeah, so let me give you some background, and
Yeah.
this is probably important for people who, like us, aren't really familiar with the scheduling system.
Hmm.
This decision was ultimately prompted um, because of a study that was completed by the FDA back in 2023. Okay, and the study was addressing the use of marijuana for medical purposes. So,
Okay.
as part of that study, the FDA found that there is, in fact, scientific support for using marijuana to treat certain medical conditions. So, a couple of examples that the order cited related to like nausea or vomiting and pain. So,
Hmm.
what most people would probably attribute to like side effects of chemotherapy or radiation, probably the most
Yeah.
familiar, right? And so, as a result of these findings, it seems like the federal uh, powers that be said, wait a second, we've got about 40 plus states and the District of Columbia, all with their own sanctioned and regulated medical marijuana programs already in place.
Hmm.
What are we
Both
doing here?
medical and
Yeah,
recreational,
medical and
depending on the
recreational,
states.
especially
Yeah.
in Michigan, right?
Hmm.
And so basically they're like, wait a second, our practices are a bit dated here. We've fallen
Yeah.
behind over the years. And by doing so, we are really limiting what we can do in terms of research for certain uh, to address certain like health gaps, right? So uh, we're limiting scientists and manufacturers and various researchers
Mhm.
from being able to actually complete critical research. So this really pushed us to help kind of fill that information gap.
Yeah, and so fundamentally, and I'm obviously paraphrasing here,
Yeah,
right?
it's
But
okay.
fundamentally, we have the Schedule 1, which is, no recognized, medical benefit here. We kind of moved away and said, hey, you know what? It seems like states are actually starting to see that there's some medical benefit here. Arguably, there is some medical benefit here, but we can't really do anything with it because if it's a Schedule 1, we really can't research any medical benefits or how to exploit those medical benefits. So it sounds like moving it into that Schedule 3 opens up not only the use of it, but more research surrounding that particular topic. Is that? Yeah.
Exactly.
Okay.
That's exactly it. Yep.
Got it. Okay. So with and we're probably getting a little ahead of ourselves here, but just by way of summary of this order, when does it go in effect? Did it talk about a timeline or, I mean the in order to go ahead and do something is, especially with the federal government, isn't necessarily a hey, let's get it done tomorrow process, right?
Yes.
So
Yeah.
is there any sort of indications we have on the timeline?
Oh gosh. Okay, so the short answer for everyone joining us is no. There is no indication of when this order is to go into effect. So when it was first signed or released, there was like a lot of buzz, right? Like we had already talked
Hmm.
about, marijuana is a big hot topic, right?
Yep.
Especially in employment and labor. So people were really kind of antsy, like, okay, does this go into immediate effect? What do we have to do? And there was initially a presumption that it was going into immediate effect and that marijuana was being rescheduled effective immediately. But when you really take the time to look at the executive order, there is nothing in there that supports immediate effect, right? Actually, if you look at it very closely, the only indication within the executive order as it relates to when it will go into effect and when the rescheduling will happen relates to the instructions that the president gave to the attorney general, where
Hmm.
the president said in his executive order the AG is to complete the rulemaking process related to the rescheduling as expeditiously as possible
Hmm.
in relation to federal law or in
Yeah.
compliance with federal law. So that, like you said, that's not exactly giving us something that we can kind of circle off on our calendar and expect and look forward to. This is something that could take, arguably months, if not longer, to actually go into effect.
Yeah.
Some people joining us might remember that because the FDA completed its research in 2023, formal action on all this actually started during the Biden administration. And since then, obviously, with turnover in administration
Yeah.
and things like that, I think there were a couple of scheduling hearings that were postponed due to appeals. There have been delays. So, I could say it could take months, but it could take even longer, just depending.
Yeah.
So we're kind of at a standstill.
Yeah. And look, fundamentally, the rulemaking process is not an overnight process.
Yeah,
You have the notice of proposed rulemaking where, you publish it in the register. People have a comment period, right, on that proposed rulemaking. A lot of different stakeholders have a lot of different views on those rules. That may result in, dismissal of the comments. It may get incorporated. There may be changes. It's not an overnight process. So that notice of proposed rulemaking is something, if you ever want to read in the Federal Register, that's one of those weird publications that no one but lawyers really review. But we'll start to see that, it sounds like, in the near future, and as that notice of proposed rulemaking actually gets issued, I think that's probably a topic for our follow-up that may give us a little bit more light onto what the federal government is thinking. So
yeah.
let's kind of understand that we don't have a date right now, right? But
Hmm.
with that in mind, what does that mean for employers now? I mean, I think the writing is on the wall. The writing has been on the wall for a while that at some point in time, marijuana is going to be moved from the no medical use to, yeah, okay, maybe there is
Right.
some medical use here, right? Where it falls on the spectrum, all those sorts of things, those are all issues that we can deal with here. But what does that mean for employers right now based on current policies and procedures, and maybe what they may want to get ahead of, in the near future, or at least start thinking about, right?
Yeah. And so I would say for those who are joining us and who might be watching this later, where we're at now is no different than we were on December 17th
Yeah.
before the executive order was released. And
Yeah.
I
And
mean
for the
that
record,
just
today
in,
is January 14th, 2026, right?
yeah, we're
Today
in no
is,
different
yeah,
of a place,
okay.
right? So we're in the same exact place we were before the executive order was released. Marijuana is still considered a Schedule One drug. So we're really just kind of operating status quo. We don't really have to change too much. Now, that doesn't mean that we can't take steps to get ahead of this, right? Which we'll talk about, I think, a little bit later. But
Mhm.
as of today, I don't want anybody rushing off this call thinking that they have to overhaul everything that they're doing from an employment perspective We do have time and we will be monitoring this and we will be giving you tools that will help you kind of assess things on a gradual basis. So, as I noted earlier, a lot of people jumped too quickly initially. And I want to give an example because I thought this was really interesting. I stumbled upon this last night actually, but somebody in Kentucky in federal court has already tried filing emergency motions regarding the executive orders,
Okay.
right? So this particular individual was convicted of several marijuana related offenses, criminal
Hmm.
charges, resulting in incarceration. And in his motions, he cited to the executive orders as grounds to hold proceedings. But the court noted that, like we just talked about, as of January, as of this
Yeah.
date, marijuana remains a Schedule One controlled substance under the
Yeah.
CSA. So in the eyes of the federal court, marijuana has no accepted medical use and a high potential for abuse. And I
Hmm.
also thought this was a funny quote, and I just share this because I thought it was funny. The court, because there is no deadline, said that functionally this executive order is a nudge to the agencies to speed up
Yeah.
the rulemaking process, to give people that guidance. So there is more consistency on the federal and state level.
Okay. Now, and I think it's also important to know fundamentally what we're talking about is just medical marijuana,
Yeah,
right? This is not an order regarding recreational marijuana. This is, and I'm sure we'll get into this in a little bit, but what the impact of it may be vis-a-vis, a prescription from a doctor as opposed
exactly.
to, some of these, recreational uses that we see, based on and obviously we don't actually have the proposed rule at this point in time, but based on the intent of the executive order, this
Hmm.
is literally just making this a prescribable, Schedule 3 drug, as opposed to, something that's over the counter or, can be used on a recreational side of it. So
Exactly.
with that in
Exactly.
mind, can we very briefly discuss kind of what the difference is between Schedule 1 and Schedule 3, because I think that'll be a good transition into what we're getting into here and how it's going to impact businesses, presumably, once the order is issued.
Yeah. Yeah. So I'll just preface this. I don't deal with the schedule very often, right, in terms of the schedule of drugs. And there are probably a lot of more drugs than I've kind of got listed for myself to share with you all. But to keep it simple, a Schedule One drug is a drug where there's no currently accepted medical use. It has a high potential for abuse, and there's a lack of accepted safety for use of that particular drug under medical supervision. So, for people like me, the things that jump out would be heroin, LSD, meth, and peyote, right? Like those are the things that kind of come to mind. I personally don't put marijuana on that list, but it's there right now, right?
Peyote was an interesting one. I mean,
Isn't it?
cocaine. I mean, something like that is probably a little bit more well known, but
I know it doesn't feel like
interesting you went
apples
with
and
peyote.
oranges on this list, but
So
so then you
what's a
jump in.
Schedule 3 drug?
Yeah, so Schedule 3 is totally different, right? So it's also three-prong test to determine if it's a Schedule 3 drug, but you're
Mhm.
looking at if the drug has potential for abuse, less than drugs or other substances in the Schedule 1 and 2 category. If there's a currently accepted medical use in treatment in the United States, right? Not other
Okay.
countries or anything like that. And if there's a potential for moderate to low physical dependence or high psychological dependence in the event of drug abuse, right? And now for those, again, what does that mean? Think about like codeine or ketamine or certain opioids that require a prescription. That's what a Schedule
Okay.
3 drug really qualifies as.
Got it. So if and let's again assume that the order goes through and it goes through in a way that we expect, right? There's not a weird, rulemaking or unique thing that's going to apply to it. Let's assume it's regulated like a Schedule 3 drug that you just talked about here a moment ago. What impact would that have on businesses, when the rule actually comes up? And again, don't have to deal with this right now, but it
Hmm.
is coming down the pipe based on the context of this executive order and barring court challenges and things like that. What kind of impact are we going to see in businesses, just generally speaking?
Yeah, so if or when marijuana is rescheduled, it will likely become available by prescription, right, for
Okay.
individuals with approved conditions, right? I know that there was a period in our history where medical marijuana cards were being given out like candy, but I think
Yeah,
that that's going to
exactly.
change or
Yeah.
has changed in certain places. But what this means is that medical marijuana users may actually be able to, defray their costs. Through their health benefits, through their insurer, right? Through
Yeah.
their employer, most likely. And this includes people who are on Medicaid. So that's a huge shift in and of itself. And because it's going to potentially get that coverage and that support from employers' benefits, what's going to what that's going to mean for our employers joining us is that there will likely be more requests to use medical marijuana as a reasonable accommodation under the ADA.
Yeah.
And why that is significant is because the ADA does not currently protect employees who use medical marijuana because as a Schedule 1 substance, it's illegal under federal law. So that's a
Sure.
huge one for employers to really think about. If this moves forward and when this moves forward, how are we going to deal with this?
Yeah, but that so I two things I want to say. So I kind of chuckled in that growing up in the time that I did, which marijuana was illegal and
Hmm.
remained illegal, right? And
Hmm.
again, it still does, right? Under federal law. But again, seeing the shift that we're at right now, being able to use your health savings account to buy a prescription for marijuana, on a tax deferred basis is just it's mind boggling to me. But,
I agree. I
it,
remember the days where there was a bunch of like medical dispensaries
yeah.
in downtown Lansing. I mean,
Yeah.
everywhere because of the influx in cards being
Yeah,
handed out.
just being able to go to CVS and apparently pick up, yeah, I guess, a pound or whatever
Ounce or two.
quantity of marijuana is being prescribed
Yeah, pick up
is,
a toothbrush, pick up
yeah, it
an
just
ounce or two. Yeah.
it's fundamentally strange to me. But I think it's important to know, as you kind of were saying, assuming this becomes a Schedule 3 drug, right? It doesn't mean that employers can't put forth policies, right? Look, you can't operate heavy equipment if you're on, oxy or something like that, right? If it's going to impair, right? It doesn't mean that it's a free for all. I think that we're going to see, as you say, the uptick, right? And it'll take a little time to get the particular guidance. And I think it's also complicated by what we've seen. And I know we're a little off topic here, but I think it's important with respect to operating under the influence, right? It's
Hmm.
very there isn't a test that I'm aware of, and again, I'm not an expert in this area, but my law enforcement people that I deal with have kind of said that there really isn't a reliable test to see if you are under the influence right now versus you smoked a week ago or used or I guess however you consumed a week ago and it's still in your bloodstream. It's not like alcohol, right? Where
Yeah.
you can do an immediate factual test to see what your
Hmm.
BAC is, right?
Yeah.
So I think it's going to be a little different as to how we're going to enforce those particulars. Whether or not there is a process, right? If you're found under the influence, if we're just going to terminate people, if we're going to send people for counseling, if you're going to send people for evaluations, and how those policies are going to be created. But I think that fundamentally, you're going to treat marijuana the same way you treat any other Schedule 3 drug, right?
Yeah.
You don't need to have a separate marijuana policy. You need to have a Schedule 3 drug policy, right?
Yeah. And I think that that's a really good point too, because if and when, like we said, if and when
Mhm.
marijuana is rescheduled and it could be used as a reasonable accommodation, it still needs to be treated in line with the employer's ADA policies and accommodation
Mhm.
policies, right? Just because they've got the medical marijuana card doesn't mean it's a blanketed, stamp of approval as a reasonable accommodation. You've got to look at what this employee does, what the employer's needs are, Is it
Mhm.
reasonable? So I don't want employers to get scared and think, well, gosh, if somebody comes to me and says that they have medical marijuana license, they can do whatever they want. No, there are still protections in place.
Yeah.
Same with any other ADA accommodation. You can still, really engage in the interactive process. There's nothing stopping
Hmm.
that.
Yeah.
And you're probably also, if I'm being honest, going to see pushback if you have unions, right? If you're an employer with
Oh, yeah.
unions, you're going to see some interesting bargaining tactics, right? They're going to
Hmm.
probably put forward some proposals, right? That the employer and the union can get behind regarding the permissive use of marijuana on the
Yeah.
job if it's medically related or necessary. On the other hand, you might see some grievances, right? If employees aren't really happy with, where the employer lands on their policies and things like that. But I think that's pretty common with any kind of ADA claim or any kind of
Yeah.
employment matter. There's going to be growing pains to it.
Yeah. Well, and that actually brings up, a little bit of an off topic, but
Hmm.
when you're contracting for, covered labor, what's the word I'm looking, joint employer, uh, you,
Multi-state?
no, not multi-state, but you hire a company to provide the
Oh,
contractor
independent
labor. Yeah,
contractors.
independent contract. It's the word I was looking for. Apparently, my coffee has not kicked in yet.
It's okay. We're
But
a team.
yeah, but do we need to have particular language in those agreements now? And again, any Schedule 3 drug is a Schedule 3 drug, right? I mean, this is not a new classification, but I also think that there may be a little bit of a different interpretation of Schedule 3 drugs between, hey, someone's prescribed, oxycodone or something like that versus someone's using marijuana, right? Is that going to involve or invoke some negotiations on the contracts, whether or not you need to test people and those sorts of things? So,
Oh, absolutely, it
again,
will. Yeah, I
yeah,
definitely
yeah.
see that being a big
Mhm.
piece of the puzzle later on down
Mhm.
the line. I mean, you're going to really want to make sure any kind of service agreement you enter into with independent contractors has the relevant indemnification clauses, insurance
Yeah,
clauses, things like that, so that it doesn't fall back on the person ultimately, hopefully the people joining us, right? If
yeah,
something were to happen as a result of somebody using medical marijuana while providing services, so you will really want to tighten up that language in those kinds of service agreements,
yeah.
um,
And
because you
and
don't want
I
to
think
expose yourself to that kind of risk.
Yeah, and fundamentally, I mean, I think that that risk exists right now, right? We're kind of dividing things into what happens when when it's rescheduled to Schedule 3 sometime in the future after proposed rulemaking. But right now, with the prevalence of marijuana, let's be honest, it's not like you can't get marijuana here in Michigan, and this executive order is going to open the floodgates. You drive down the road, there's 5 different dispensaries, processing centers, things like
Hmm.
that, right? So the existence of marijuana in Michigan is a right now issue,
Yeah,
right?
yeah.
And I think that that's one of the things that employers can take away. In that if they haven't started addressing those policies and those areas in the contract, they may want to start doing that right now, independent of the executive order,
Agreed.
right?
Agreed.
So while we're talking about it, because we talked about Michigan, right? You have the other side of the coin, which is multi-state employers, right? Because I don't want to assume everyone on the call is just defined into Michigan, and you run into the dichotomy between federal law and state law, and how you have to deal with the compliance of that. So can you
Hmm.
kind of give us a little bit of a preview? Again, let's assume for the moment that marijuana is Scheduled 3 and it's scheduled like any other drug. Can you give us kind of an idea of what multi-state employers should have on their radar?
Yeah, so multi-state employers are in a different category, right? Like you said,
Hmm.
because you're not just dealing with Michigan, right? Because that's where we're at, or just the federal regulations. You've kind of got to look at how each state handles medical marijuana and recreational marijuana now, right?
Hmm.
You've got to look at how each state addresses it independently. And you've got to cater your policies to each respective jurisdiction. Because in your situation as a multi-state employer, your one size fit all policy isn't going to
Hmm.
work for you and
Yeah.
really could get you in hot water if you're not paying attention to what your policy says. Or maybe you drafted it years ago just to be in compliance and haven't looked at it since. But that's going to get you the grievances, the lawsuits, all that fun stuff. So I would
Yeah.
really encourage you, first and foremost, as a multi-state employer, to, check your policies and make sure you have developed a particular policy for each jurisdiction in which you operate to make sure that that aligns with your state, right? Because New York, for example, I think they have limitations on like drug testing pre-employment compared to
Hmm.
Michigan. So if you are somebody who operates here in Michigan versus New York, right there, your testing policies and procedures are going to be different. So you want to make
Yeah.
sure they align accordingly. I would also say, and you touched on this before too, there's no test for impairment when it comes to marijuana use as there is for using alcohol in the job, right? I don't think there's a sobriety test. I'm touching my nose for folks who can't see me on camera right now. There's nothing equivalent. So um, it's more subtle signs, right? Maybe delayed speech or delayed body movement. So I would
Hmm.
prioritize training in all of your jurisdictions on how to look
Yeah.
for signs of impairment if there are signs, because at that point you really want to prioritize safety in the workplace
Yeah.
over penalty, because I think that's really the key for you guys and could
Well,
ward
and
off like workers' comp issues
it,
and stuff.
yeah, and to springboard off of that, I fully expect that worker comp, administrators are going to be issuing some sort of, guidance and tests and
Hmm.
things like that as this becomes a little bit more prevalent. We've already started seeing it on the recreational side, right?
Hmm.
What to watch out for, but with it becoming, a Schedule 3 drug, states that don't allow the medical or the recreational use. And there's always been this dichotomy between federal law and state law, right? I mean, we were talking about that 5 years ago, when we started, down this path, and it could be off on the timing, but maybe
Hmm.
actually a little longer than that here in Michigan, right? But you've got to comply with both federal and state law, right? And for the longest time, Michigan and other states were, kind of ignoring federal law, not
Yeah.
really ignoring it, but taking the position of, state doesn't need to enforce federal law. And
Yeah.
you kind of had that handshake agreement where, the Fed said, hey, if you're complying with state law, we're not gonna,
Yeah.
really
We've
enforce
got
it
bigger
for
fish to fry.
most. Yeah,
Yeah.
exactly. Someone comes in with 3 tons of marijuana across the border, it's a little different, story than, someone
Hmm.
who's, recreationally, has a joint or a gummy or something like that, right?
Hmm.
So I think that states are going to have some interesting rules on this.
Hmm.
And I think that there's going to be some support from, the workers' comp, the insurance, advocacy groups, in order to make sure that we can spot the signs to address, the risks that are associated with it, along with evaluating reasonable accommodations, right? We're going to
Yep.
see that coming down the pipe. But again, you evaluate it like any other Schedule 3, and based on the
Hmm.
the non-rule that we have right now. So in the last minute or two that we have here, and we talked about a few things, but what practical steps can be done right now, for training, for updating policies, reducing legal risks. Again, understanding that we do not yet have a rule, so we don't know what's in that rule. We're obviously
Hmm.
limited on that. But what sorts of practical things can we get started on today, assuming that this is going to be coming down the pipe?
Yeah, so kind of like what we had talked about before, review your drug testing policies, review your compliance policies when it comes to using marijuana or any other kind of substance on the
Hmm.
job. Make sure it is clearly written, make sure it is accessible to your employees, and make sure that they know where they can go to ask questions about those policies. Because I will say one thing that's come out of this executive order is the confusion, because there are a lot of folks that do believe that this
Yeah.
executive order relates to all uses of marijuana, criminal, recreational, medical, etc.
Hmm.
So people are really kind of operating with different facts, and we want to make sure from an employment perspective they're all operating on the same page. So
Yeah.
even though we don't have to make major modifications regarding the rescheduling, it's never a bad practice to review and update your policies and protocols when you can. And training, I think training is always a good thing. So whether it's training, department heads or managers or whomever on how to observe signs of using marijuana on the job, or training employees on safety practices and
Hmm.
expectations. I think all of that is really key because if you can start a good foundation now, it'll be much easier to carry it over if and when this executive order really kicks off, right?
Yeah.
Because they'll have that built-in foundation and understanding of what your expectations are. And you've got a track record of consistency at that point
Yeah.
because I'll tell you what always hurts an employer is lack of consistency. You treat one situation different than the other,
Right.
and
Yeah.
you are asking for litigation or a grievance or, a complaint, right?
Yeah.
So just, consistency, I think, is important.
Yeah.
Um, and look at how you manage accommodation requests. What is your current practice right now? I just talked to an employer the other day who didn't even have an ADA policy, and I'm not judging. I know a lot of people are guilty of that, but you really want to make sure that you've got an understanding of how the ADA works and how reasonable accommodations work and how you want to handle those. And not all employers are going to be able to handle them the same way, right?
Hmm.
But having that in place is going to be key. And then I'll just say this too, and this is not self-promotion, but when in doubt, I really encourage you guys to seek out legal counsel, right? Because Rob said we're reading, all the boring stuff a lot of folks don't want to read. We're monitoring legislation. We're keeping track of things on a regular basis in real time. And we want to empower you guys with the right information so you're not walking yourself into a minefield. So, those are the couple of tips I would give to folks right
Yeah.
now, along with
And
the encouragement not to panic. We're in this with
yeah.
you to help you get
And
through
and
it.
I think you talked about it, but the other one that I think I want everyone to take away right now is read the executive order.
Yeah.
Have the script. Be prepared to talk about, what was in the executive order, what the timing is, what the scope is. Because there is a lot of misinformation. We've received several phone calls, to your point, people saying, well, hey, I heard the executive order was for all marijuana use, right? Not just Schedule
Mhm.
3, or Schedule 3 is treated like Tylenol, right?
Yeah.
Or it's effective today, and I want a reasonable accommodation based on
Hmm.
it today, right?
Yeah.
And look, there may be some state law, implications that you have to deal with, so it may not be that much of a change, but be prepared to discuss
Hmm.
and correct, some of the misconceptions surrounding this executive order. Again, it's a process. It's not
Yeah.
an overnight thing. So,
Hmm.
I know we could spend hours talking about this, but we're actually over a few minutes here. I want to be respectful of everyone's time. What I will say is this is still, an ongoing area of law. We're going to continue to monitor it. Once we get the notice of proposed rulemaking, you'll find some additional resources on our website here. I'd like to remind everyone we have another session coming up on February 11th. Topic to be announced, so watch your emails on that topic. And again, I'd like to thank Courtney for taking time out of your day to come in and talk to us, on this topic. And I'm sure that there's going to be some follow-ups once there's a little bit more meat on the bones of
Yeah.
of the Schedule 3 change. But I think that everyone can walk away from this knowing that it is very likely, barring any court challenge, that there's going to be a pretty dramatic shift in drug policy regarding marijuana. I mean, I can't, other than making it recreational, I can't imagine, a bigger shift from completely illegal to now it's prescribable and you can go to
Agree.
CVS and get it,
Yeah.
right? It's definitely not something that, if you would have asked me, 20 years ago, I would have thought to see in my lifetime. So
Oh, never in a million years. Yeah.
yeah. So again, thank you very much for your time. Thank you everyone for attending today's session. Again, wish we had a little bit more meat on the bones of this executive order, but we're playing the hands that we're dealt with, and we'll continue to monitor the topic. So please check our website for any other updates. So again, thank you all for attending, and I hope you have a fantastic week and Happy New Year's to everyone, and hope you have a great 2026.